Ladies and gentlemen, welcome back to the Indie Zone podcast. Judge Stephen J. Hippler rendered a written ruling concerning the state of Idaho's motion in Limine regarding alternative perpetrator evidence. You can find it in the very long order of April 18th, where the court has memorialized to writing a number of in limine rulings that he made during the hearings back on April 9th, 2025. And this ruling is beginning on page number 5. It addresses the defendant's possibility of raising evidence of alternative perpetrators, including those who may have been previously cleared by law enforcement. Let's see what the court's guidelines here are. The state seeks an order prohibiting defendant from offering, quote, alternate perpetrator, end quote, evidence without first making a showing that such evidence is relevant and admissible under IRE, that is Idaho Rule of Evidence 401, and IRE, Idaho Rule of Evidence 403. These rules, per the court, ladies and gentlemen, govern the standard of admissibility for alternate perpetrator evidence, citing to State versus Meister. This is a seminal Idaho Supreme Court case from 2009 that both parties agreed provides the legal standard governing the issue of alternate perpetrators. The court is quoting from the Meister case, quote, mere inferences that another person could, italicized here, have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of IRE 403, end of quote. Defendant acknowledges his burden under Meister, but argues the state's motion is premature. According to the defendant, this case is, quote, full of alternate perpetrators, end quote, and he intends to produce offers of proof as to alternate perpetrators. While defendant is correct that such offers of proof can be made at trial, this case is not well suited to waiting until the time of trial to do so, particularly if defendant intends to submit multiple offers of proof. This means multiple possible alternate perpetrators. There would need to be an offer of proof, ladies and gentlemen, for each and every one that satisfies the Meister standard and the governing rules of evidence. This order continues at the bottom of page 5. Laying foundation for the admission of the evidence will likely take going to the top of 6, significant amount of time. After all, defendant cannot merely show another person could have committed the crime. Rather, there must be, quote, evidence, and then in parentheses, direct or circumstantial, end of parentheses, linking the third person to the actual perpetrator of the crime. Then the court continues to avoid undue delay at trial. Defendant must present the offers of proof no later than May 14th, 2025, so that the matter can be addressed at the pretrial conference. There's a footnote here, footnote 5. This says, the scope of the preclusive effect of this ruling includes suggesting that specific individuals looked at and cleared by law enforcement are alternative perpetrators without first complying with the showing required by this order. So, bottom line is that any people who were previously cleared by law enforcement appear to be game as long as the defense can meet this standard. Can't just go out there and ambiguously state somebody could or might. There must be hard evidence, either direct or circumstantial, that points to this third party. The court's order continues. The court will reserve ruling on the motion. So what the court's going to do here is give the defense until May 14th to file them by that day in time for a discussion the next day, the 15th of May, which is when the final pretrial conference is set to occur. They will probably be filed under seal because the defense would need to name who these alternative perpetrators are, along with the evidence that points them toward possibly being the true perpetrators of the crime, to raise reasonable doubt. Thank you for joining us here today.